It's Monday, June 9th, and it's 4:20 somewhere in the world. I'm your host, Radical Russ Belville. Produced and distributed by the National Organization for the Reform of Marijuana Laws in Washington, D.C., this is your NORML Daily Audio Stash, the growing truth about cannabis. Welcome to the most popular podcast regarding marijuana in all of America and all the world, featuring interviews with scientists, politicians, doctors, prohibition policy activists, regular cannabis consumers, musicians, artists, and NORML staff and NORML's board of directors, along with music and comedy no other podcast can offer. You can always find out more about the show at our website, stash.normal.org. and continue the education and conversation on our blog as well. We're ending marijuana prohibition with education, one listener at a time. The podcasting and blogging technology for the NORML Daily Audio Stash is provided by Red Aphid Interactive Media. Visit www.redaphid.com. Well, welcome to the Daily Audio Stash, friends and listeners. And wow, we're back from the NORML Aspen Legal Seminar. And I'll tell you, I had quite the time up there. So much new information to take in, as well as some of the best social events I've ever been a part of. It really was a tremendous outing. And I did learn something. Did you know that when you smoke marijuana in Aspen, Colorado, you'll get 8,000 feet higher than when you smoke it in Portland, Oregon? I've got about 10 hours worth of videotape from the seminar. We're going to cut that all up and get some audio clips for you for all this week. So we're going to do something a little different. No interviews this week. I'm going to be playing you clips from the conference where you can learn some of the latest trends, legal trends with regard to marijuana in the United States from some of the greatest experts. You're going to hear from Jerry Goldstein on new court decisions at the state and federal level. Paul Wright from Prison Legal News was there talking about prisoner litigation and prisoner constitutional rights. Our own Deputy Director, Paul Armentano, talked about the latest DUID research, drug driving research. Natman Shea was there for teaching ethics to prosecutors. Douglas Hyatt, Warren Edson, and William Panzer all held a panel on the current medical use issues that are happening. Dan Monnett told us about the failures of drug dogs. Jerry Merritt of TalkLeft.com gave a presentation on crack cocaine sentencing. John Wesley Hall, the president-elect of the National Association of Criminal Defense Lawyers, gave us some information on roadside search and seizure. Scott Jerdam talked about reasonable doubt, and Marjorie Russell gave us a preparation to bring your case to life, which also featured a live reenactment of the famous Keith Stroup Boston Freedom Rally pot bust. I'll have video for that up on the web as soon as I can get it all edited. So, we'll check that all out, and also behind-the-scenes access to Owl Farm, Hunter S. Thompson's famous home in Woody Creek area of Aspen, Colorado. Anita Thompson had us out there for a wonderful party on Saturday, live music. I even got to get up and jam a little bit, which was a true honor, and I got some great photos there from Hunter Thompson's house. So check that out on the web. I've got a few of them up already at stash.normal.org. All right, so sit back and relax with your favorite strain and enjoy today's NORML Daily Audio Stash. Now it's time to take a look at the latest stories about marijuana from news organizations across America and around the world in our NORML Daily Audio Stash, Hemp Headlines. San Bernardino and San Diego counties appeal to overturn medical marijuana in California. From signonsandiego.com. 19 months after a judge rejected San Diego County's lawsuit against the state of California seeking to overturn medical marijuana laws, government lawyers are returning to court to argue their appeals. In a case being watched closely by counties around the state, oral arguments are scheduled for 9 a.m. Tuesday in a 4th District Court of Appeal courtroom in downtown San Diego. Lawyers for San Diego and San Bernardino counties will argue that the state cannot force counties to issue identification cards to qualified medical marijuana patients because the drug is illegal under federal law. The state will join lawyers for sick and dying patients in arguing that San Diego Superior Court Judge William R. Nevitt Jr. ruled correctly in 2006 when he said the county must follow state law and issue the cards. In 1996, 56% of California voters approved Proposition 215, which allows chronically ill patients to grow and smoke marijuana to relieve symptoms related to their sickness. 7 years later, amid confusion and lackluster support for medical marijuana among many law enforcement and local elected officials, then-Governor Gray Davis signed a bill requiring counties to issue identification cards to qualified patients. Staff Attorney Joseph Elford of Americans for Safe Access, another advocacy group that represents medical marijuana patients, said he expects San Diego and San Bernardino counties to take their case to the California Supreme Court if they lose this appeal. It's extremely political, said Elford, who is meeting with a group of patients Tuesday night to update them on the case. Quote, the boards of supervisors from San Diego and San Bernardino counties are opposed to what the rest of the state and the people in their own counties voted in favor of, end quote. Sometimes I'm just stunned at the huevos grandes some of these elected officials are sporting. It's a wonder they can even walk. Between this case and the case in Haley, Idaho, I just can't believe that the elected representatives of the people feel it is their duty to sue their bosses, we the people, who have voted in large majorities to support the medical use of marijuana. Regardless of how you feel personally about it, you're elected to represent us and to uphold, protect, and defend the laws of we the people. The laughable scam that is medical marijuana. Now, I'm surfing through the intertubes when I came upon this little bit of syndicated opinion from the North Star Writers Group. The boundaries between the justifiable purpose of the substance and the not-so-underground culture of recreational use have blurred, and it's not doing law-abiding users any favors. We're an image-driven culture, so no matter how many reports and physician testimonials about marijuana's medical efficacy another acronym-happy organization comes up with, a single shot of a pharmacy with a neon 420 sign flashing and Grateful Dead poster speaks for itself. In California, the ease with which a prescription can be obtained, relying solely on the patient's word and then filled by a vending machine, is laughable. To convince the nation that marijuana is a legitimate drug reserved for extreme cases, either start putting Vicodin in Pez dispensers or start treating Mary Jane like a potent controlled substance. Vendors insist that the machine's increased security, comparable to an ATM, will make it possible for people to access marijuana after store hours. Anyone who has driven up to their pharmacy only to remember that it's not open 24 hours knows how frustrating not having access to necessary medication can be. Then again, pain relief, whether rolled into a joint or in a child safety sealed bottle, is not an emergency. If we don't vend insulin, there is probably a good reason to not vend BC Bud. You can't treat the substance as a harmless, easily available helper and then show up at legislative hearings and talk about it as if it were the miracle drug that belongs on the pharmacy top shelf. Well, first of all, as someone who just recently experienced the sudden, excruciating pain of kidney stones and called 911 for an ambulance for the first time, I have to disagree that pain relief isn't an emergency. And this writer doesn't even address someone dry heaving to the point of choking to death, a person for whom a spasm or a seizure can be severely harmful, or someone who suffers from severe PTSD. However, she does hit upon an interesting point about the medicalization of marijuana, the dichotomy of medical and recreational use. But she draws the wrong conclusions. It's not that doobie puffers have perpetrated some fraud about marijuana's medical efficacy. It's that the government has perpetrated a fraud about marijuana's alleged dangers. New York activist Dana Beal in jail. Cures Not Wars founder and marijuana activist Dana Beal is currently being held in an Illinois prison on suspicion of money laundering. Bail has been set at $250,000. Beal runs the annual Global Marijuana March from his New York office. Beal needs $25,000 to make bail. He also needs cash to make phone calls and use the commissary. You can help Dana Beal. Overnight, express mail, or FedEx any money orders or cashier's checks directly to Irvin Beal, Coles County Jail, 701 7th Street, Charleston, Illinois, 61920. All of you who can help, please do. Part of the way the drug warriors fight this insane war is by taking down our leaders. People like Dana Beal put a lot of time and effort into helping us all stand up for our rights through efforts like the Global Marijuana March. We need to all stand together and pool our limited resources of time, talent, and money because we're facing the full force and fury of the federal government and its billions in resources. We've got truth, compassion, and commitment on our side, though. Do what you can. Even $5 can cover the cost of a phone call from Dana to his family. If everyone reading this blog and listening to this podcast gave $5, Dana Beal could walk out of the Coles County Jail, and a good man would get a small karmic reward for all his hard work. To get that address again, just check it out on our blog at stash.normal.org.
Hello, I'm Paul Stanford from the Hemp and Cannabis Foundation, or THCF. Medical marijuana is legal in 12 states today, and THCF has medical clinics in 6 of those states. Our physicians help qualified patients obtain an authorization for medical marijuana in their state. Patients are eligible for medical marijuana with a history of either severe chronic pain and or nausea, cancer, AIDS or HIV, hepatitis, glaucoma, seizure disorders like epilepsy, chronic muscle spasms as in multiple sclerosis or asthma, neurodegenerative diseases such as Alzheimer's, and gastrointestinal disorders like IBS or Crohn's disease. If you or someone you know has one of these conditions, our doctors will help them obtain a permit for medical marijuana. THCF Medical Clinics has offices in Washington State, Oregon, Colorado, Nevada, Hawaii, and California. Call 1-800-723-0188 or go to the web at www.hemp.org or 1-800-723-0188.
All right, like I said, we're going to bring you some of the highlights from the NORML Legal Seminar in Aspen, Colorado this last weekend. And we begin with Jerry Goldstein, an attorney from San Antonio, Texas. You may have even seen him on Court TV from time to time. He did an incredible presentation on what he called his top 10 important new decisions for all drug law reformers and lawyers to know about. So we pick up with Jerry Goldstein as he's talking about some of the important decisions in case law.
What I'm going to try and do very quickly here is go through what I consider my new top 10. My top 10. Some old, maybe new, but the things that concern me these days. And there are many. Let's start with number 10. Number 10 is Hudson versus Michigan. How many of you are familiar? This is the new majority. It's the first real case out of the Supreme Court where the Roberts new court with Alito have spoken up. And it deals with knock and announce. Remember, that was what we always thought. There was a statute that said they had to knock and announce before they, police, I thought it wasn't a big deal. Well, Justice Thomas, of all people, in a unanimous Supreme Court case in 95, held that the knock and announce requirement was inextricably intertwined within the Fourth Amendment's reasonableness requirement. That it was a constitutional mandate, not just a statutory one. Then some 7 years later, the Supreme Court held they can knock, wait 15 seconds, then fucking blow your door down. Not a lot of time, but some. Then came Hudson and our new majority. This is from June of last year, about a year ago. 2 years ago, excuse me. In particular, it's one of Scalia's classic opinions. He's joined by the Chief Justice, Thomas, and Alito. Concurring? Kennedy. This is the new concurrence. Remember, it was Senator O'Connor before. Kennedy was in the right-wing branch. Just take the whole picture and move it over a little bit to the right, and now Kennedy is our swing vote. We've gone a substantial distance to the right, folks. Dissenting, the obvious group of four. Breyer, Stevens, Ginsburg, and nice Mr. Souter, who lived with his mom there in New England. Hudson versus Michigan was interesting because it dealt with the knock and announce requirement that Thomas had told us with the unanimous court was part and parcel of the reasonableness requirement of the Fourth Amendment to our Constitution. And they said, despite the fact that the officers admittedly violated the knock and announce requirement of the Fourth Amendment, and despite the fact that that was the but-for cause of finding the evidence, the Supreme Court said the exclusionary rule didn't apply. Why? Because, they said, we look to the purpose that is fostered by that particular constitutional guarantee. And knock and announce is designed to protect the safety of the officers and those inside, and is not part of the privacy concerns of our founding fathers. And Scalia goes on to talk about, he says, we've never held that evidence is fruit of the poisonous tree simply because it would not have come to light but for the illegal acts of the police. Bullshit. I mean, 40 years I've been practicing on that basis. Where did this come from? And then when he explains it to us, he says, suppression of evidence has always been our last resort, not our first impulse. Well, not maybe his. The exclusionary rule generates substantial social cost. Well, that is true. If there's nothing, they don't find any shit. There's nothing to exclude. So the exclusionary rule only benefits, quote, the bad people, us, which sometimes includes setting the guilty free and the dangerous at large. Dangerous. They're different. They're foreign. They're not us. We have repeatedly emphasized that the rule's costly toll upon the truth-seeking and law enforcement objectives presents a high obstacle for those urging its application. What happened to the old Scalia? Remember his opinion? First one out of the box. The police officers go into this tenement in Phoenix. There's a bullet hole in the ceiling. They, under the safety exception of the warrant requirement, they bust into the apartment above looking for a weapon or an assailant to protect the occupants. Remember? And they abandon their safety purpose for a moment, and because they see a lot of expensive stereos, this guy obviously couldn't afford that kind of shit. So they lift the stereo 3 inches, read the serial number, call it in, and their suspicions were confirmed. Stolen stereo. And Smith says that was a search. That there was nothing immediately apparent about the illegality of that stereo. You had to do something to it. Lifted it 3 inches. And what happened to this, Scalia? There is nothing new in the realization that the Constitution sometimes insulates the criminality of a few in order to protect the privacy of us all. I like that, Scalia. That's the Scalia I like. Next comes the Plain Field case, the Dickinson case, written by Kennedy. And in that case, they're doing a Terry pat-down, and they feel a small object, they manipulate it between the index finger and thumb, and they feel something, and the officer says, crack cocaine. All right? And the court says, like lifting the stereo 3 inches, it was not immediately apparent that was evidence. Manipulating it between your index finger and thumb, like lifting a stereo 3 inches, constituted a search. Scalia says, look, if I had been on the court when y'all decided fucking Terry versus Ohio, I would have never gone along with it. Our founding fathers would have never allowed the police to lay hands on them on mere suspicion. I like that, Scalia. That's the one I like. That's the one I like. But what about Scalia's idea that, how the fuck does he know what the original intent of our founding fathers was? What does he come off telling us what it was? I mean, think about this. All men are created equal. They meant that. They were not gender perfect. Women didn't get the right to vote or sit on juries until 50 years after African Americans did. Jefferson, who allegedly penned those words, had slaves, like one or two of them, apparently. If you think about it, liberty can't be the exclusive domain of the privileged few. Freedom can't be exclusively for the majority, excluding the African American, the people of color, the Hispanics, the Catholics, the Jews. Or it's not freedom you get. This is Scalia, by the way, speaking to the Federalist Society in Philadelphia. He says, people who believe the Constitution would break if it did not change with society are idiots. Well, I'm an idiot. I don't think it's just men. I do think our Constitution has broadened its view, its concept of who is created equal. I think our concept of our constitutional rights has to expand. And by the way, so does Scalia when it serves his interest. Remember Crawford, the cross-examination confrontation case? Remember it had to be testimony, and all of a sudden, what the fuck's testimony. We leave that for another day. Well, another day came in David versus Washington, and he talks about the fact that we no longer have Marian magistrates, but we got cops. And he uses this language. He says, you know, restricting the confrontation clause to the precise forms against which it was originally directed is a recipe for its extinction. Fucking that's a living, breathing Constitution. He understands it when it serves his interest. Call out from Hudson. This idea that we look to the purpose underlying the constitutional right we're trying to assert in order to determine whether we're going to apply the federal exclusionary rule. Hector. Hector's a case where the officers failed to leave the search warrant that's required under statute to leave the search warrant with the occupant of the premises. What the Ninth Circuit said was, even if that were a constitutional requirement under Hudson, that has nothing to do with protecting the privacy of the house. Doesn't matter whether you comply with it or not. Under Cesares Olivas, the Seventh Circuit, same kind of, this is one of the Title III, the federal telephonic warrants. And you have to reduce a telephonic warrant to writing after you, but it's too late for anybody to read it, but after you execute it, it's got to be reduced to writing. They didn't do that. They said, well, that the purpose in that, like in Hudson, was not to protect the privacy of the individual. What the fuck was it to protect? Anyway, U.S. versus Cost. This is an interesting case. This is a 10th Circuit case, and this is a case where they rely on the consent of the person who's present. And they said, remember, under Schneckloff and those other cases, they can rely on the consent of someone who has absolutely no right to give it, as long as they're acting reasonably. They said they were unreasonable here. You gotta just read the facts of this case. It's hilarious. They walk in, the guy said, fuck, it's not my house, I don't give a shit. So they said, okay, you know. I guess so, you know. Well, they relied on that kind of consent. But what's interesting is what the 10th Circuit said. They said, we view Hudson as being limited to the knock and announce requirement. I'm not sure that other circuits are going to do that, but it's a good case. All these are in the materials, too, by the way, folks. U.S. versus Rice is an interesting case because it deals with a wiretap, a Title III wiretap. And what the Sixth Circuit says in Rice is, look, the Hudson exception, look to the purpose, the good faith exception under Leon are both judicial nuances based on a judicial remedy. You know, the Constitution doesn't say you exclude evidence obtained illegally. That was a judicial remedy in order to protect our rights of privacy. So they said, well, that was judicially created under the whole clause, so these judicial nuances, but Title III, federal wiretaps, has its own statutory exclusionary rule. Therefore, neither Hudson nor the Leon good faith exception apply to Title III warrants. Oscar Torres is a more interesting case. This is a case, remember Davis versus Mississippi. Remember it was a classic case. There's a rape of a white Anglo female, elderly female, and all she can tell him is it's a black guy and he came in through the window. There's a couple of fingerprints on the windowsill. They go up, round up all the black people in this small Mississippi town, take all their fingerprints, and match one up. And the Supreme Court said, you can't do that. You got to have probable cause, at least reasonable suspicion to stop somebody, probable cause to arrest them, and you had neither in this case. Well, what they're saying here is that fingerprints that are taken routinely as an administrative process, under Hudson, they're not excluded. But if the fingerprints are taken for an investigative purpose, then they are. And what's interesting about what they say is that, for example, when they stop undocumented individuals, we know that although it's an administrative process to take down their fingerprints, what they're really doing is trying to look for some excludable offense. So there's a criminal investigative purpose. And they said, even though that was an administrative type of fingerprint, the purpose in the officer's mind was more investigative, more criminal investigative in nature. Breaking news, Virginia versus Moore. By the way, and I'd like to see, we're going to get to it in a minute, but think about that. Remember how the Supreme Court said we never looked at subjective intent? Bullshit. Okay, Virginia versus Moore. This is from 2 months ago, and another crushing blow to the Fourth Amendment by the new court. Remember New York versus Belton? How many of y'all remember the Bright Line Rule case? Remember, you can search the entire passenger compartment of any vehicular stop, so long it is what? A custodial stop. All right, that's the rule. If it's a custodial arrest, then you can search the entire passenger compartment. Well, what's interesting is this Chubbs Moore is driving down the road. He's got a suspended license in Virginia. They stop him and search the passenger compartment under Belton's bright line rule. The problem they have is, under Virginia law, you can't arrest somebody for a suspended driver's license. You got to ticket them. Well, what does Scalia says? He says, well, hang on. We're not going to use the federal exclusionary rule to enforce state law. All right? And therefore, Chubbs Moore is doing his time. Again, he looks to the original intent. This is how he decides it. He says, we look to the common law of the founding era to determine the norms that the Fourth Amendment was meant to preserve. And he uses language like, they had general warrants and writs of assistance. Remember, the King George's Redcoats had the leather writs of assistance. They just go bang down your front door and rummage through your underwear drawer. Well, that's interesting to go back and look at the norms of the common law at the founding moment of this country. But quite frankly, intrusions into our right of privacy are a little more sophisticated today. There's nobody banging down our door all the time. Some of that new technology is stealth-like. They're stealing our thoughts, not our underwear. You can't feel it, you can't see it, you can't taste it, and perhaps it's more dangerous and more sinister because of that. Because what it steals from us is our thoughts. It steals something at the crossroads between our Fourth Amendment right to be free from unreasonable searches and seizures and our First Amendment right to free speech, to right of association, to right to bitch about our government. And that has a chilling effect on the citizenry. And I'll be damned if that was anything that the Founding Fathers thought about. They thought about a chilling effect, but they had no idea they'd be able to look through walls or listen to conversations many miles apart. That's something that Scalia fails to understand.
Just say no.
No matter what you call it, it's a huge part of popular culture.
Where'd you learn that, Cheech? Drug school.
You don't need weed school. You just need a copy of the new book, Pot Culture, the A to Z Guide to Stoner Language and Life.
Hey, this is great, man.
Even if you never smoked marijuana.
I never used marijuana. Sorry.
Don't think you smoked marijuana.
I experimented with marijuana a time or two and didn't inhale.
Or you used to smoke marijuana.
I inhaled frequently. That was the point.
Pot Culture by former High Times editor Steve Bloom and Shirley Halperin will answer every question you ever had about marijuana culture.
Has that marijuana made it back up here yet?
Check out Pot Culture, the A to Z Guide to Stoner Language and Life at Amazon.com or visit potculturebook.com today.
Too bad, man. I just stopped smoking yesterday.
Here at the Normal Daily Audio Stash, we work hard to change our nation's marijuana laws through education and discussion. But we also take the time to relax and unwind with an eclectic mix of pod-safe music from many independent artists. We look for music that speaks to the growing truth about cannabis, or music that speaks to broader themes of freedom, liberty, social justice, equality, and protest. To find out more about the artists and download the music you hear on this podcast, just log on to stash.normal.org. And if you'd like to get your music heard by the online cannabis community, just send us an email at stash@normal.org. Welcome to Blues Monday. It doesn't get much bluer than the Chicago Blues. And today on the Stash, we have Chicago blues legend Billy Boy Arnold with the hit New Jailhouse Blues. I don't think that you get to enjoy a podcast if you're behind bars, but if any stasher has been able to enjoy the Normal Daily Audio Stash while incarcerated, let us know by leaving a comment. Unfortunately, far too many cannabis consumers have had a stint as a POW. Billy Boy Arnold began playing harmonica as a child in Chicago, and in 1948 received informal lessons from his near neighbor, Johnny Lee, or Sonny Boy Williamson, shortly before his death. In 1952, a small record company gave Arnold the nickname Billy Boy on his recording debut. New Jailhouse Blues is a track from a long overdue album, recorded in 1992, but released just last month. Billy Boy Arnold comes full circle with a wonderful tribute to his mentor, the original Sonny Boy, John Lee Williamson. Make sure to check out our blog at stash.normal.org, where you can find out more information about the album. Billy Boy Arnold sings Sonny Boy, John Lee Williamson, and you can get a download of this song on MP3. This is Billy Boy singing New Jailhouse Blues.
Now when you're in the new jail in Jackson, man, and you didn't know what to do. Now when you're in the new jail in Jackson, man, and you didn't know what to do. Now then you wanted to go out walking, but they wouldn't let you out on the avenue. Man, I was just sitting here thinking, man, I was thinking all to myself, you know, I was just sitting here thinking, man, I was thinking all to myself. I was just thinking my woman didn't love me. I hope she ain't in love with nobody else. Lord, and I don't want him to lose no time. I want Fred to go to Lolly May. You know, and I don't want him to lose no time. Now I want to get out of this jail, because I want to go and see that little woman of mine. I want you to call up the judge. I want you to ask him what's my fine. I want you to call up the judge. I want you to ask him what's my fine. Now I think they all knows me. I've been here so many times.
Almost busted in Laredo, but for reasons that I'd rather not disclose.
I smoke pot, and I like it a lot. Hi, this is Willie Nelson. I learned a long time ago that marijuana is a lot safer to use than alcohol. There's absolutely nothing wrong with the responsible use of marijuana by adults. It's time we stopped arresting and started respecting responsible marijuana smokers in America. And to learn what you can do to help, please contact NORML at www.NORML.org. NORML.org or call toll-free at 888-67-NORML.
The show was long and we were just sitting there, and we'd come to play and not just for the ride.
For our second segment here on The Stash, I'm going to give you some audio from a presentation by Dan Monett of Wichita, Kansas. This was on Saturday morning when he made this presentation called Drug Dogs, Putting on Your Own Dog and Pony Show. And with so many cannabis consumers who end up going to jail because of the alert from a drug dog, it's in your best interest to understand how they work and where they come up with some of these figures for reliability. Dan does a really good job of showing you just how they fudge the numbers to come up with such supposed statistics as 98% accuracy from drug dogs. So enjoy this presentation. This is Dan Monett with Drug Dogs, Putting on Your Own Dog and Pony Show.
Well, if we get all these records and we do these kinds of cross-examinations, does that mean that we're going to necessarily win our client's case on cross-examination when we do it in the courtroom? Well, not necessarily. I mean, you all have probably done enough of these cases to know that. But we're doing what we always do by getting the records. We're looking for a needle in a haystack. We're panning for gold. We're trying to strike it rich. And sometimes just asking for the records can help you resolve the case in a way that's favorable to your client. As some of you may know, that's what happened to us in the actual case of Wink of the Wonder Dog. Our client's serious felony possession of cocaine was dismissed in exchange for a misdemeanor plea to possession of Valium, and they would recommend probation on the curious condition that defense counsel agreed to remain muzzled about the contents of Wink of the Wonder Dog's veterinary records and canine search forms. And Doug Parr probably knows I had a case down in Oklahoma with stalwart criminal defense attorney J.W. Big Daddy Coyle in a rural part of Oklahoma where the client had gotten busted on what I call an Oklahoma IQ test roadblock. You know, that's where you're coming down the highway and there's a sign that says, next exit, last exit before drug checkpoint. So where does everyone get off? At the next exit. Where's the drug checkpoint? At the next exit. Cops are there, stop the car, dog barks, search the trunk, find 2 kilos of cocaine. We filed all these motions for the kinds of records that we're talking about. Didn't get much response. We finally issued some subpoenas to the officers. We came up to the preliminary hearing in kind of a backwoods Oklahoma jurisdiction with a funky prosecutor who had a big plug of tobacco in his cheek as he was talking to us. He called us in from the prelim and said, well, I want to talk to you, J.W. You know, you boys have asked for all these records on this dog, and I haven't sent you any because I don't think there is any record. That wasn't any special dog. That was Billy Bob's farm dog. And that's what it was. Billy Bob's farm dog was there. Car stopped, kicked the dog barked, searched the trunk, find the drugs. Dismissed at preliminary hearing. Well, what about the statement in the affidavit for search warrant that Wink of the Wonder Dog is 98% reliable? That brings me to the second thing I want to talk about. Let's consider making a Franks versus Delaware attack on the truthfulness of those representations in the affidavit for search warrant. Remember, Franks versus Delaware is the case that says that if there are statements that are recklessly or made in reckless disregard of the truth or are false in the affidavit for search warrant, and the search warrant is deficient to establish probable cause, when those statements are set aside, then suppression is in order. And cases subsequent to Franks have established that if there are misleading omissions from the affidavit that likewise have the effect of misleading the magistrate, then so too suppression is in order. And again, a Frank's motion is a good motion to make because Leon's good faith exception to the exclusionary rule does not protect Frank's situations. So how do we make the Frank's attack on the affidavit for a search warrant? Really, we need the same records that we need to successfully attack the reliability of the alert of the dog on cross-examination. And this isn't strictly a cross-examination question. We're going to use those records to make a substantial preliminary showing under Frank's of a falsehood, reckless statement, or material omission in the affidavit. Then we're going to use the records to prove up that violation on a leading direct examination of the handler. I remind us all that Federal Rule of 611C allows us to lead the handler as an adverse party. That then brings us to the fun and value of these records for cross-examination or for establishing a Frank's violation, because when you get these records, you find the creativity that the handler often uses to describe what is a find and what is not a find. For instance, here's a canine narcotics search form on Winka the Wonder Dog, where she alerts on the scent of drugs on the left back fender and an area between the seats. However, no drugs were found. Now, do they count that as an indication with no drugs found? No. Look under the yellow part. No. They count it as an indication with no drugs found. Or with drugs found, excuse me. Why? If you look at the last sentence here, because it is believed that drugs may have been transported in the plastic tub. So whether it's a find or not depends upon the sheer speculation of the biased handler. Here's another canine narcotics search form that we got on Winka the Wonder Dog, where Winka is exposed to a black bag and a blue bag. And she alerts on the black bag twice, but no drugs are found in the black bag. Drugs are in fact found in the blue bag. Now, do they count that as an indication with no drugs found? No, even though no drugs were found in the black bag. Do they count it as an indication with drugs found? Yes. Why? Because if you look at the last sentence here, it says the black bag had clothing that looked to have been worn and was traveling with the blue bag. As you can see, the handler gets very creative with how he keeps the batting average of his best friend. Sometimes he's willing to find a find depending on whichever way the wind blows. Here's another canine search form where they go in and they find some cash on the floor of an apartment. So they want to find out if there is drugs on the money, or if the money is associated with drugs in any way. So they hide the money in a file drawer, and then they ask Winka to look for it. Winka indicated on the file drawer on the north side of the file room. A check was made and nothing was found. Thereafter, Winka indicated on the scent of drugs on a file drawer on the south side of the room. Now, do they count that as an indication with no drugs found? No. Do they count it as an indication with no drugs found on one occasion and an indication with drugs found on another occasion? No. They just count it as an indication with drugs found. Why? Because if you look here at the bottom, the best friend of Winka took a lighter and placed it on the floor where the money was originally found. I was able to determine that the air coming into the room was hitting the floor where the money was placed and going across the room to the north side where the file drawers are located, this being the location that Winka first alerted on. So if we get such information, it's valuable for cross-examination, and it shows you just how much fun you can have exposing the way they keep statistics on their best friend. Question, and what happened was that Winkle was exposed to a black bag and a blue bag, correct? Correct. Question, she alerted on a black bag for the scent of drugs, correct? Answer, correct. But no drugs were found in the black bag, correct? Answer, correct. 10 ounces were found in the blue bag, correct? Well, that's right. Question, so in the bag she alerted on no drugs were found. That's right. One question, would you put these down in your computation as an accurate hit by the dog? Answer, well, of course I would. Even though it was on the wrong bag, my opinion, it was on the right bag. If you get the records and do the math, you can see the curious mathematics. Let me try to take questions at the end, please. You can see the curious mathematics by which they come up with these astronomically high reliability records. Here's a canine search form where Winker the Wonder Dog is exposed to 1,000 lockers, 500 in the high school, 500 in the middle school. She alerts on 11 lockers. No drugs are found. Now, how does the scorekeeper figure that in to Winker's batting average? Question, in those 1,000 lockers, she indicated on a total of 11, correct? That's right. Drugs were not found in any of the lockers, correct? Answer, well, that's true. Question, and at the top of the canine search form, you have written indication with no drugs found. Yes, correct? That's right. And when you factor that canine search form on the maze lockers into your calculation, you count it as 1 incorrect alert rather than 11 incorrect alerts. And of course, everybody knows that's how you figure 11 strikeouts in a batting average. Well, with those kinds of records, are you going to be able to prove that the dog is unreliable? You know, probably not, because the way I read what probable cause means, it doesn't require 98% reliability. In fact, probable cause doesn't even require more than 50% probability in the Fourth Amendment context. So we may not carry the day that way, but a false statement, a known false statement in a court document makes everybody nervous and unhappy except you.
Thank you for downloading the NORML Daily Audio Stash, the growing truth about cannabis. We are produced by the National Organization for the Reform of Marijuana Laws in Washington, D.C. Our executive producer is Alan St. Pierre. Our deputy director is Paul Armentano. Our webmaster is Brian Judy. And web production is provided by Red Aphid Interactive Media. As always, you can catch up on the latest information about marijuana at www.norml.org. And you can interact and download from our Audio Stash blog at stash.norml.org. For everyone here at NORML, I'm your host, Radical Russ Belville, hoping all your harvests are bountiful and your encounters with law enforcement are non-existent. We leave you today with another one of our cannabis quotes, this one from Abraham Lincoln, the great emancipator. Quote, "Prohibition will work great injury to the cause of temperance. It is a species of intemperance within itself, for it goes beyond the bounds of reason in that it attempts to control a man's appetite by legislation and makes a crime out of things that are not crimes. A prohibition law strikes a blow at the very principles upon which our government was founded." End quote. Couldn't have said it better myself, Honest Abe. Prohibition has got to go. I'm Radical Russ. Thanks for joining us here at the Daily Audio Stash. And until next time, take care of each other, tokers.